Raymond absent.
Yes, my lord.
First defendant is represented by who?
Eku.
By who?
Uneku. Egbe.
What's his position?
Principal legal.
Appearances.
Okay, sorry. May I please, Honorable Court, CM Uche Enwere. Appearing me, Your Lordship, is KA14. Most humbly, Your Lordship, we make appearance for the claimant in this case.
Very well. Any other appearance? Any other appearance? No appearance for the defense. Go ahead.
EA Oshayomi is my name, sir. EA Oshayomi.
EA
Oshayomi. Yes, my lord. In this case, my lord.
Very well.
Most obliged, sir.
For very well. Here is the judgment of the court. This action was commenced by a general form of complaint dated and filed on the 6th of January 2017 and was subsequently amended on the 27th June 2018, wherein claimants sought the following reliefs. One, the claimant claims a sum of 114,386 naira 59 kobo per month with effect from April 2016 as salary, and also claim his entitlements, allowances, and benefits will be deferred from 1st April 2016 until the matter is determined. Two, a declaration that the appointment of the claimant is on pensionable status with full rights to gratuity, pension, and other benefits allowed under the public service rules as his appointment is regulated by statute and regulation. Three, a declaration that the claimant's appointment was unlawfully determined or terminated and is entitled to his salaries at the sum of 114,386 naira 50 kobo per month with effect from 1st April 2016. A declaration that the termination of the claimant's employment with the first defendant is unlawful, illegal, void, and of no effect, same having been carried out in flagrant disregard to the public service rules and the first defendant's condition of service. Five, another that the appointment of the claimant is on a pensionable status with full rights to gratuity, pension, and other benefits allowed under the public service rules as his appointment is regulated by law and statute. Six, another that the claimant's appointment was unlawfully terminated and is entitled to his salaries at the sum of 114,386.50 per month with effect from 1st April 2016 and other allowances and benefits until termination of his case. Seven, a declaration that the claimant is entitled to all his salaries and allowances. From the first defendant, they resort to public service rules as well as the first defendant's condition of service in disengaging the claimant. Eight, a declaration that the demotion of the claimant from the position of principal technical officer 1 to principal technical officer 2 is flagrant and for the same offense went ahead to terminate the appointment of rules and the first defendant's condition of service was unlawful, illegal, null, and void of no effects. 9, a declaration that the refusal of the second defendant and his officers to acknowledge the appeal written by the claimant in accordance with the civil service rules, onward transmission to the chairman, Federal Civil Service Commission, was in flagrant with regard to the public service rules and amount to denial of the right of fair hearing. Therefore, unconstitutional, illegal, null, and void. 10, a declaration that the sealing up of the claimant's official residence, known as Flat 13A, Road E2, Kaduna State, Ajaokuta, Kogi State, for about 8 mental right as enshrined in the Constitution. 11, and order that the to Principal Technical Officer 2 in flagrant and for the same offense went ahead to terminate the appointment of the claimant, amounts to double jeopardy and contrary to public service rules, and the first defendant legal null and void of no effects. 12, and order that the refusal of the second defendant and his officers to acknowledge the appeal by claimant in accordance with civil service rules or translation to the chairman federal rules and amount to deny of the right of fair hearing and therefore constitutional, illegal, and null and void. 13, of the second, an order that the second defendant refusal to transmit the appeal written by the claimant which he received but failed at commission or consideration as provided by the Public Service Constitution. 14, an order of perpetual injunction restraining the second defendant and any of his acting office should be acting official residence of the claimant, known as flat text to the final determination of the suit. 15, an order for the defendant to reinstate the claimant as principal technical officer, and 1, as the termination of his appointment was unlawful and contrary to the PSR and in breach of fair hearing and due process, and is entitled to all salaries and benefit with effect from 1st April 2016. 16, general damages of 500,000 naira only against the defendant, and 17, costs of filing prosecuting the it is a claimant case that he was employed by the first defendant as craftsman, mason, and joinery, which appointment was subsequently confirmed. He was converted from supervising officer cadre to principal technical officer cadre upon completion of his national diploma polytechnic. He was last promoted to principal technical officer 1 on level 12, step 3. November 26, former at the still making shop of the department was surprisingly demoted from the rank of principal technical officer 1 to principal technical officer 2. However, his appointment was subsequently terminated on the 31st of March 2016 on the ground of ongoing reorganization of the company without prior notice or salary of notice or facing a disciplinary committee, which decision he appealed to the chairman, Federal Civil Service Commission, in line with the public service rules. Equally petitioned the Public Complaint Commission, whose decision is to the effect that the demotion and termination of his appointment is double jeopardy. In the same vein, the Public Service Commission communicated to the defendants that his termination and demotion is unlawful, illegal, null, and void the night of the day, as he was never invited by the defendants. He approached the court, and whilst in court, the defendant locked up his quarters without a court order. It took the intervention of the Public Complaint Commission for the quarter to be open after 8 days. He ordered the court to rule that his demotion and termination of his employment is unlawful for being employment. The defendants, in response, by the amended, admitted that claimant was an employee of the first defendant, but his employment has been terminated by the management of the first defendant for service no longer needed. Claimant was queried following the incidents of vandalism of a transformer and other electrical installations at the electrical unit of the steelmaking shop of the first defendant due to his failure to carry out routine check on the electrical installations. Consequently, a committee was set up and he found him not to have satisfactorily answered to the allegations by the claimant. It avert further that no longer required upon giving the claimant 1 month notice or salary in lieu of notice, and claimant was paid the salary in lieu of notice in April 2016. That claimant neither expressed the satisfaction or protested against his demotion, but resumed duty as Principal Technical Officer 2, that the employment defendant condition of service 2005, that going by the first defendant policy, an employee whose services has been terminated after severance of the employment, and claimant on his own voluntarily handed over the keys of his apartment, and claimant on his own surrendered the keys, handed over the keys of his apartment to the manager accommodation department. His appointment was not locked up. His apartment was not locked up. He only pleaded for 2 months' grace to vacate the apartment, after which he vacated. Claimant has refused to make himself available for enrollment as a pensioner, having failed to complete the process of documents which he had started. On the 17th of November 2020, claimant opened his case. He testified for himself. He adopted his witness statement, tendered documents admitted and marked as Exhibit 00 to 011. He was cross-examined by the defendant. And on the 16th of November, the defendant the defense called one Mr. Boyi Kwajafa as their witness, who equally adopted his sworn position, tender documents at trial. Then the counsel on behalf of the defendants filed his final written address. I've reduced that into the body of the the claimant as well filed. I've reduced all that into the body of the judgment. Let me go straight to the decision of the court. Carefully perused process filed in this case, the exhibit tendered by both parties, and the final written addresses of both parties. I'm of the view that the issues that best determine this case are: 1, whether the employment of the claimant, and 3, whether the claimant is entitled to this is a contention of the defendant's right freedom of defense. So the final written address that the second defendant is not competent before this court. Parties in this case have argued back and forth on this issue. Thus, the castles believe the feuding parties whether or not the second defendant is a legal off. I thought it's only my children. I would connect back. So let me take this again. Respecting issue 1, it is a contention of the defendants right from their pleadings as contained in paragraph 1 of the amended joint statement of defense up to the written address that the second defendant is not competent before this court and that he is a non-juristic personality. Parties in this case have argued back and forth on this issue. Thus, the casus belli between the feuding parties is whether or not the second defendant is a legal personal ficta, which can be sued or can sue in non jomin, and one who possesses all the right to harness all the entitlements of the juristic personality. There's no doubt that the question of juristic personality and jurisdiction are intrinsically related. This is because the issue of juristic personality of the second defendant touches and affects the jurisdiction and competence of the court over the second defendant. See the case where now Ngeri citation captured The case of Socio-Political Research Development and Ministry of FCT and others, citation also captured. It is only a legal person that can sue and be sued. Thus, where a person is not a personal victor, he can neither sue nor be sued. In the case of medical merchandise versus Pfizer Inc. and another, citation captured, Eagle GSC had this to say on who a juristic person is. I quote him: juristic persons who may sue or be sued in domain have been recognized to include: 1, natural persons, that is to say human beings; 2, companies incorporated. Under the companies are 3, corporations aggregate and corporations sole with perpetual succession; 4, certain unincorporated association granted the status by law, such as A, registered trade unions; B, partnerships; and C, friendly societies or sole proprietorships, unquote. From the above definition, it is clear that a juristic person can either be natural or artificial person. See also the case of Reptico SA Geneva versus Afribank Nigeria PLC, citation captured. The second defendant in this case is not a natural person. Juristic personality is usually conferred on artificial persons by law. In the case of Abubakar and others, this is Yaradua and others, citation captured. The Apex Court per Toby GSC of blessed memory held those, and I quote, juristic or legal personality can only be denoted by the enabling law. This can either be the Constitution or a statute. If the enabling law, a party must sue and be sued in that name. He has no choice to sue or be sued in any other name. In other words, juristic or legal personality is a creation of statute, and a party which seeks relief must comply strictly with the enabling statute. The position of the law is as stringent and as strict as that, unquote. It must be noted that such juristic personality usually conferred by statute or artificial persons by statute are conferred expressly or impliedly. See the case of Calabar municipal government and honesty, citation captured. It then means that capacity to sue and be sued is not given by mere recognition or acceptance of existence, but strictly conferred by law, whether expressly or impliedly. Thus, a person or an office is not clothed with the toga of juristic personality by the mere fact of its existence. See Socio-Political Research Development and Ministry of FCT and other supra. Companies and allied matters act, which gives legal personality to companies and under which first defendant as a limited liability company was registered as same as with K7, from where it derives its legal personality, did not clothe the second defendant with such legal personality. The claimant who wants the court to believe otherwise, the second defendant is a juristic personality, has not placed before the court any law or statute conferring juristic personality on the office of the sole administrator of Ajaokuta Steel Company Limited, that is, the second defendant. The first defendant, to my mind, both at common law and under the repealed Companies Decree 968, is a personal figure who can only act through an alter ego, either by an agent or servants. See the case of Pasco, Interdrill Nigeria Limited, this was UBA PLC, citation captured. The second defendant is merely an alter ego of the first defendant through which the first defendant acts. That does not clothe the second defendant with the status of a personal victor, which the first defendant enjoys unless it is either expressly stated or by necessary implication in a statute. From the facts of this case, there is no doubt that such office exists. However, the mere fact of its existence will not give it the toga or title of legal personality with the capacity to sue and be sued in that name. I'm not unmindful of the submission of the counsel that the court has power to clothe an office with the toga of juristic personality in its interpretative function, while relying heavily on the case of Minister of Defense and Ephraim Supra. Let me remind Learned Counsel that the decision of the court in that case is unambiguous and the rationale for same is not in doubt. First, the second and fourth appellants in that case, whose juristic personality were called to question, were offices created under the Constitution of the Federal Republic of Nigeria, 1999, as amended hereafter referred to as the Constitution, and the Armed Forces Act, Laws of Federation of Nigeria, 2004, with specific statutory functions, and which was the main reason the court found that though the law did not specifically give them the power to sue and be sued in their name, by virtue of their statutory duties, they can be clothed with the toga by the court, which means that they were accorded the state status by the court by necessary implication. In the instant case, the second defendant has not been shown to have been performing any statutory duty. Thus, the case is clearly distinguishable from the fact of this case. It must be noted that juristic personality cannot be given to a person without statutory duty or function, or an office which is not alluded to in any statute. Thus, I find no reason why this court should, in its interpretative powers, clothe the second defendant with the toga of juristic personality, as Learned Claimant Counsel would want this court to do in the circumstance. In view of the above facts, which are rooted in law, I am unable to agree that the second defendant is a personal victim. Thus, question 1 is resolved against the claimant. The proper order to make where a party lies juristic personality is an order of strikeout. See the case of Calabar Municipal Government and Honesty Supra at page 432, paragraph D. It is in the light of this that I strike out the name of the second defendant from this suit.
As call, please.
In the same vein, it is a tried principle of law that the court cannot make an order against a non-party in the case. See the case of Ararume and Uba citation captured. Since the name of the second defendant has been struck out, it is equally clear that the court does not have jurisdiction to make the declarations and grant orders which claimant is seeking in reliefs 9, 12, 13, and 14 in the amended general form of complaint against the second defendant. It is therefore expedient that those reliefs suffer same fate as the name of the second defendant. Accordingly, reliefs 9, 12, 13, and 14 are struck out for want of jurisdiction.
As the call, please.
Before addressing issue 1, let me point out that I'm aware of the second issue. I'm aware of the second issue, which was equally raised by defendant in paragraph 1 of the amended joint statement of defense. Also in the competence of this suit. The defendant read paragraph 1 of the amended joint statement of defense also raised objection to the competence of the suit on the ground that necessary parties are not before the court. However, the defense counsel in his final written address did not advance any argument in support of this. In the case of Onomade and ECB citation capture, the apex court, while faced with a similar issue, held per Ugu GSA retired does, and I quote, "An issue a preliminary objection in respect of which no argument is advanced in the brief of argument, therefore not canvassed before the court, must be deemed abandoned," unquote. See also the case of Mboye and Ugunsiji, citation captured. The case of Ajibade and Pedro, citation provided. The case of R versus Ipaye, citation captured. I will accordingly treat the above issue in paragraph 1 of the amended statement of defense as regard the competence of this suit for failure to join necessary parties as abandoned, and the same must be and is hereby struck out.
As a call, please.
On issue 2, Learned Claimant Counsel has maintained that claimant's employment is one clothed with statutory flavor. Let me first address the contention of parties as to whether or not claimant pleaded or made reference to the statute creating his employment or the statute which provides for the terms and conditions governing the appointment and termination, in respect of which parties argued in their final written address. A perusal of the amended statement of fact clearly shows that claimant did not plead specifically the statute creating his employment and did not plead the specific condition of service governing his employment. However, it is worthy of note that claimant in paragraph 4 of his amended statement of fact made specific reference to his letter of employment and confirmation of employment dated 12 November 1992 and 4th April 2001 respectively, herein as exhibit 01 and 02. It is well settled in law that documents legally speaking speak for themselves. The case of Olukemi and Airtel Networks Limited, citation captured. Ezu and Ochie and Idigbe, citation provided. Eze and Abga, citation provided are on point. I peruse both exhibits, particularly the letter of confirmation with the finery of a tooth comb. Admirably, it is obedient to clarity and comprehension. It states that claimant shall be entitled to all rights and privileges of the permanent staff as contained in the defendant's condition of service, civil service rules of Nigeria, and such regulations and conditions as may be adopted from time to time. In the case of CFAX Nigeria Limited and McCoy Nigeria Limited Supra, the Supreme Court held that where reference is made to a document in the pleading, such document automatically becomes part of the pleadings. See also Access Bank PLC and Uboja citation provided. It is thus clear that the content of Exhibit 02 is part of the pleadings and the court can rightly make reference to any content of the document. Exhibit 02 has made companies' condition of service and civil service rules of Nigeria applicable to claimants' employment. It is obvious from the content of the said Exhibit 02 that the primary condition of service governing the employment is the company's condition of service, while the civil service rule or public service rules, hereafter referred to as the PSR, will be secondary. The point must be made that claimant all through this case did not tender the company's condition of service, which is the primary condition of service regulating his employment. The said condition of service is not a subsidiary legislation which the court may take judicial notice of. Failure of claimant to tender same is very fatal to his case of unlawful termination of employment. It must be noted, however, that Exhibit 02 did not specify the specific civil service rules of Nigeria that would be applicable. That is, it was not delineated by law. By year. It is notorious fact that there are several editions of the rules made by the Federal Civil Service Commission, which are usually delineated by year. It is a cardinal principle of our labor law that an employee alleging unlawful termination of employment must plead as a cardinal part of his pleading the particular condition of service governing his employment. Such an aggrieved employee must aver it as a cardinal issue in the pleadings and also lead evidence in the court of non-compliance with the terms and condition of service. So the case of University of Calabar and SCN citation provided. The case of Ogumka and CSD citation provided. The notorious case of Idoniboye Ogu and NMPC citation also provided. Assuming that by the decision of the Apex Court in the case of CFAX Nigeria Limited and McCoy Nigeria Limited Supra, the content of the said Exhibit 02 is already part of the pleadings. It is needful to state that the PSR is a subsidiary legislation. As such, the court can take judicial notice of it. See the case of Access Bank PLC and Uboja Supra. That said, it is in my candid view that failure of the claimant to plead the company's condition of service, which is the primary condition of service governing his employment, is fatal to his case, as I've stated earlier. It would have been a different case if there was no existing condition of service in this case. But there is, as averred by the defendant, and which condition of service was pleaded and tendered by the defendant herein as Exhibit K2. The court cannot apply the PSR to the claimant's employment to the exclusion of the company's condition of service, which is the primary condition of service as stated in his letters of employment and confirmation, respectively. It is where the provisions of the company's condition of service is insufficient on his contract that the court will resort to the provision of the PSR. Be that as it may, then I counsel on behalf of the defendant in his final written address argued that claimant's employment is not one clothed with statutory flavor because one of the conditions that must coexist for there to be a statutory employment is not present as claimant, who has the onus to prove that his employment has statutory flavor, has not placed before the court the law which established the defendant. Then I counsel for the claimant in his final written address while acknowledging that truly two conditions must coexist for there to be an employment with statutory flavor, and that the defendant is a creation of the National Steel Council Act, Laws of Federation, hereafter known as the NSC Act. They refer the court to sections 1 and 2 of the Act. As third parties are added them, that for an employment to be clothed with statutory flavor, two conditions must coexist, namely A, that the employer is a body set up by statute, and B, that the condition of service is contained in a statute or regulations made pursuant to a statute. See the case of Kwara State Judicial Service Commission and another versus Tolani, citation captured. The case of PACN and Ofoelo Supra. There's no doubt that from Exhibit 02 that parties intended the applicability of the PSR to the employment relationship between parties, although same is secondary and cannot be applied to the exclusion of an existing condition of service of a defendant's company for reasons earlier given. The condition of service of the defendant Exhibit K2 is a primary condition of service. The said condition of service Exhibit K2 cannot be said to have statutory flavor, as it is neither statutory nor is it a subsidiary legislation to have statutory flavor. Also, it didn't take its power from any statutory legislation. As stated supra, the PSR is made applicable to the employment, though secondarily. It must be noted that the mere fact that the PSR is made applicable to an employment does not in itself clothe the employment with statutory flavor. In fact, the condition of service of the company going by Exhibit 02 is the first applicable condition of service before that of the Civil Service of Nigeria, which makes the PSR secondary in this case. As stated supra, two conditions must coexist, which conditions have been captured supra for an employment to be construed as one lays with statute. It is clear, beyond doubt, and I'm in agreement with the Learned Claimant Counsel position in his final written address, that the PSR is a condition of service with statutory flavor, as the PSR is itself a subsidiary legislation to the Constitution, as stated earlier. See the case of Comptroller General of Customs and Reserve Supra, which was relied upon by Learned Claimant Counsel. As such, one can say the second condition is present in this case. A major point of contention between parties from their submissions in their respective final written addresses is whether or not the first condition, which requires that the employer must be a creation of statute, is present herein. As stated supra, claimant has argued that the defendant is a creation of the act. It is expedient at this stage, therefore, that I consider the relevant provisions of the NSC Act that claimant is relying on. Hereunder reproduce are the relevant provisions. Section 1 provides us, and I quote, establishment of National Steel Council. 1. There is hereby established a body to be known as the National Steel Council, and this act referred to as council, which shall have the functions assigned to it by this act. Subsection 2. The council shall be a body corporate, perpetual succession, and a common still and be sued in its corporate name. Subsection 2, section 2, membership and tenure. Subsection 1 of section 2. The council shall consist of a chairman to be appointed by the president on the advice of the minister and the following other members, that is, A, one representative each of the following ministries: industry, finance, power, and steel. B, the chairman of the board of directors of the companies specified in subsection 2 of this section, being companies set up by the federal government, 1, and related minerals necessary for the production of steel, or 2, to produce steel or byproducts thereof. Subsection 2, the companies referred to in paragraph B of subsection 1 of this section are as follows: A, the Ajaokuta Steel Company Limited; B, Delta Steel Company Limited; C, Batagarawa Steel Company Limited; D, the Jos Steel Company Limited; E, Oshogbo Steel Company Limited; and F, the Associated Oils Mining Company Limited. As the minister may, by order in the Federal Gazette, add to, delete from, or otherwise amend the foregoing list of companies, and references to companies in paragraph B of subsection 1 of this section shall be construed accordingly, unquote. The above provision of the NSC Act is clear and requires no special aid to understand. It is well settled that in the interpretation of statutory provisions, the provision of a statute must be interpreted in context of the whole statute and not in isolation, to bring out the intention of the legislature, and the words used must be given their plain and ordinary meaning. See the cases of Omiano versus Anekwe, citation captured; the case of Dematic Nigeria Limited versus Utuk, citation captured; the case of Lawan and Federal Republic of Nigeria, citation provided. With greatest respect to Learned Claimant Counsel, His argument that the defendant at Jakarta Steel Company was created by the NSC Act, going by these provisions, can sadly not fly. The holistic consideration of the said NSC Act from sections 1 to 13 and the first and second schedules will clearly show that it was only intended to set up the National Steel Council and not to establish any of the companies referred to in section 2, subsection 2 of the Act. The above provisions, particularly section 1, is clear that what was created or established under the NSC Act is the National Steel Council and not the defendant, the Jakarta Steel Company, or any of the companies mentioned in subsection 2 of section 2 of the NSC Act. The intention of the legislature is clear, and interpreting the said provision to mean that the NSC Act did set up the defendant's company will negate the true intention of the legislature. Besides, the words used are clear, and when given their literal and ordinary meaning, does not show that the defendant company or any of the listed companies were set up under the NSC Act. The words used are clear to the effect that the defendant company was merely given representation on the National Steel Council and nothing more. The fact that the NSC Act recognizes the defendant as one of the companies whose chairman would be a member of the National Steel Council does not mean that the defendant or any of those companies was established under that act. In the case of Moses and MBA citation captured, the habeas court held inter alia when considering whether recognition of NBA in the Legal Practitioners Act gave it juristic personality, held inter alia those, and I quote, the Nigerian Bar Association is not a juristic person, and so it cannot be sued legally in its name. The constitution of the association is not a statutory instrument. It is a pure and simple private document which members of the association were entitled to draw up in exercise of their right to provide a constitution for the association to regulate its affairs. It was accorded due superior position by the Legal Practitioners Act and the conduct of its affairs by the General Counsel of the Bar. This does not make the association a juristic person. It only gives the body recognition as a legal entity. The fact that the legislature has in the Legal Practitioners Act and the Legal Education Consolidated, etc. Act, given the association representation on the body of benches and Council of Legal Education, is not an indication that the legislature constituted the association as a suitable entity, unquote. Although the above is on the juristic personality, it can also be applied to an extent in this case. The mere fact that the defendant at Jakarta Steel Company Limited was given representation on the National Steel Council by the NSC Act or was named as one of the companies established by federal government does not translate to mean that the defendant's company was set up by the act or created under it. The defendant company was duly incorporated under the Oil Companies Decree 1968 and registered as a limited liability company shown on Exhibit K7. In fact, a perusal of Exhibit K7 clearly shows that the defendant was not registered until the 6th of November 1979. The date of the commencement of NSC Act, as seen in the said act, is 18th of September 1979. In essence, the defendant was only registered as a limited company almost 2 months after the commencement of the NSC Act. So it is not true that the NSC established the defendant. The NSC Act established the defendant. To say that the defendant was set up by the NSC Act would mean to say that the defendant is a statutory corporation which got its legal or corporate personality from the said NSC Act. The defendant did not get its existence or legal personality from the said NSC Act. In fact, the defendant is not a statutory corporation that is set up by statute. Rather, it is a company set up by the federal government as alluded under Section 1, subsection 1, paragraph B of the NSC Act, and all other companies listed thereunder. The only body that the NSC Act created and which obviously got its legal existence from the NSC Act is the National Council of Steel. Consequently, I find that the defendant is not a body set up by statute, and in such instance, its employment cannot be one clothed with statutory flavor, even though the PSR is made secondarily applicable to its employees. I may want to argue that defendant being a company owned by the federal government, which fact is notorious, is part of a public service by the provision of Section 318 subsection 1 of the Constitution of the Federal Republic of Nigeria as amended, and as such has its employment clothed with statutory flavor. It is clear that an employee of a body established by statute is a public servant. See the decision of the Supreme Court per Sanusi GSC in the case of Avery and Naipo's citation captured, wherein the Apex Court held us. In this instant case, the appellant was employed under the Nigerian Postal Service Act, Laws of Federation, which by its section 1 had established a Nigerian Postal Service, which is also a body corporate, which can sue and be sued. Section 9(1) of the Act had also given the board the powers, although subject to the approval of the minister, to regulate the activities of the board and also to appoint and discipline, e.g. dismissal or termination of appointment, any of its erring staff. Goes without saying, therefore, and as rightly found by the two lower court, that the appellant is simply a public servant, even though he cannot be regarded as civil servant, unquote. The question at this stage is, can the same be said of an employee of a company set up by government? The Supreme Court has already answered this in the case of Awala, a Nigerian Telecom Supra citation captured, where it held that a limited liability company incorporated under the Companies and Allied Matters Act 2004, or any other law under which such company is registered, whether owned by government or by private persons, is governed by its rules and condition of service and not by the civil service rules. The court also went further per Abaji, GSC, to hold those, and I quote, under section 2771 of the 79 Constitution, public service of the Federation was defined as the service of the Federation in any capacity in respect of the government of the Federation, and included service as staff of any company or enterprise in which the government of the Federation or its agency owns controlling shares or interests. However, that did not mean an employee of government-owned companies was therefore a public officer. The definition was reflective of and particularly consistent with the provisions in the 5th schedule to the Constitution, which dealt with the Code of Conduct for Public Officers. Interpretation paragraph of 21, paragraph of 21 of the schedule defined public officer to mean a person holding any of the offices specified in part 2 of the schedule. That part provided for public officers for the purpose of Code of Conduct contained a long list which included staff of statutory corporations and of companies in which the federal or state government has controlling interests. In this case, the mere fact that the appellant was employed by the respondent, a company wholly owned by the federal government of Nigeria, did not by itself mean he was a public officer. I must say, unquote, I must say, by the decision of the Apex Court in Awala and Nigeria Telecom Supra, which decision by the doctrine of judicial precedence I'm bound by, it is abundantly clear that the mere fact that government set up a company or own controlling shares in it does not in itself make an employee of such a company public servant or a member of a public service whose employment is ordinarily clothed with statutory flavor. The employment relationship between parties in this case is obviously governed primarily by the terms and conditions agreed between parties in the appointment letter, and the condition of service and as such is that of an ordinary master servant rather than one clothed with statutory flavor. In view of all the reasons above, I have no doubt in holding that claimant's employment with the defendant is not one clothed with statutory flavor. As such, question 2 is resolved against the claimant.
Please.
Before addressing issue 3, I'd like to address the arguments of parties as to admissibility of Exhibit K8, that is the minute of meeting of the committee. According to learned counsel on behalf of the claimant in his final written address, Exhibit K8 having not been front-loaded or pleaded is inadmissible, and the court should expound same from its record. Learned counsel on behalf of the defendant in his reply address maintained that the said Exhibit K8 is admissible because facts relating to it were pleaded in paragraph 41V of the amended statement of defense. Generally, admissibility of document is based on relevance. Put differently, relevance is a precursor to admissibility. Once a piece of evidence is considered relevant and it is not legally inadmissible, it will be admitted in evidence. See the case of Owaka and RSHPDA citation captured. The mere fact that a document was not front-loaded will not render it inadmissible, especially where it was pleaded or alluded to in the pleading. See the cases of Abubakar and INEC citation captured, Uboru and Udraga citation provided. Thus, the fact that the said exhibit K8 was not front-loaded should not ordinarily affect its admissibility. What matters here is whether or not the document is relevant to the facts in issue. Learned counsel on behalf of the defendant has stated supra, I'd argue that the document need not be specifically pleaded and that it was the minutes of meeting of a review committee, which was alluded to in paragraph 42V of the amended joint statement of defense. It is clear from the pleadings and evidence before the court that there were two separate committees which were set up by the defendant as regards the allegation made against Claiborne, namely the Committee of Inquiry and secondly, Review Committee. I've gone through Exhibit K8 with the mastery of an eagle eye, and I find that contrary to the assertion of Learned Defense Counsel, Exhibit K8 is the minute of meeting of a review committee as they asserted. Rather, it is, the Exhibit K8 is not the minute of meeting of a review committee as they asserted. Rather, it is the minute of meeting of the Committee of Inquiry. And I'll proceed to state why. First, the perusal of the said Exhibit K8 will show that the heading of the document states that it is the Committee of Inquiry and not the Review Committee. Secondly, Exhibit K9, which contains the report of the Committee of Inquiry, clearly states on the first paragraph of the second page that the Review Committee sat on Thursday, 10th day of December 2015, and made recommendations. A perusal of the disputed Exhibit K8 clearly shows that the minutes covered the period between 21st August 2015 to 22nd of September 2015, respectively, and as such, could not have been the minutes of the Review Committee, which sat on the 10th of December 2015. Thirdly, a perusal of Exhibit K9, particularly the last page, shows the membership of a Review Committee with the name of the chairman and secretary clearly spelled out. A perusal of Exhibit K8, the disputed document shows that a separate person is the chairman who signed the minutes contained in Exhibit K8. Thus, the chairman who signed Exhibit K8 is different from the chairman of Review Committee as contained in Exhibit K9, even though the same person signed as secretary of both. Thus, it is clear beyond doubt. Exhibit K8 is the minute of meeting of the Inquiry Committee and not minutes of the Review Committee as Learned Defense Counsel will want this court to believe. Having resolved this, the pertinent question at this stage is whether the said Exhibit K8, being minutes of the Committee of Inquiry, was pleaded. It is tried principle of our law, all that documents need not be specifically pleaded. It is sufficient if the facts contained in the documents were pleaded or alluded to in the pleadings. See the case of Access Bank PLC versus Uboja Supra, Chidulua and Atanse citation captured, Ojo and Kamalu citation provided. I've come through the amended statement of defense of the defendant, and I find that the defendant did not specifically plead the said minutes Exhibit K8. However, in paragraph 42(3) and 4, the defendant averred that Management Committee of Inquiry was set up to investigate the allegation against the claimant, and claimant appeared before the committee and defended himself. A perusal of the said exhibits shows that its content is the recording of what transpired at the meeting of the Committee of Inquiry and contains the defense of the claimant before the said committee. In my view, the said document is in support of facts pleaded by the defendant in paragraph 42(3) and 4 of the amended statement of defense. Besides, the said document is relevant to the facts in this case. I'm here to see how admitting this document or considering its content will infringe on claimant's right to fair hearing, as Learned Claimant's Counsel proceeded in his final written address. The claimant himself in his pleadings did not deny appearing before the said Committee of Inquiry. This court also notes that on the 11th of November 2021, when the defendant tendered this document and a number of other documents, Learned Claimant Counsel stated openly in court that he had no objection. It is his duty to go through these documents at the point they were to be tendered and object to the admissibility of anyone he feels should not be admitted for whatever reasons which he failed to do. I do not see a reason why Learned Claimant Counsel should now in his final written address be crying foul about infringement of the claimant's fundamental rights by the admission of the said document marked as Exhibit K8. In view of all reasons, Supra, I find that the said Exhibit K8 is relevant to the facts in issue and thus admissible in evidence, even though it was not specifically pleaded by the defendant. The question of the probative value is another issue entirely. I so find and hold. It is claimant's claim that his demotion is unlawful because for non-compliance with the terms of employment in the public service rules. Claimant pleaded facts relating to this in paragraph 24 of the amended statement of facts. It is his contention that the investigation committee set up to investigate the alleged offense did not allow him to face trial for those criminal allegations before a court of competent jurisdiction. The defendant, on the other hand, maintained that claimant's demotion was done in line with Exhibit K2, and he was indicted for failure to organize the unit properly by failing to inspect the electrical unit and leaving the steel-making shop in complete darkness, and all his indictment was for gross misconduct and not a criminal offense. See paragraph 42, 1 to 7 of the amended joint statement of defense. The effect of the above is that the defendant is maintaining that claimant was not found culpable of any criminal offense but of a misconduct. It is a well-settled principle of our law that when an employee is alleged to have committed an act which amounts to crime, the proper venue for determination of same is the court of competent jurisdiction. See the case of CBN and junior citation captured. The pertinent question at this stage is, was the claimant alleged to have committed any criminal offense which will necessitate his trial before a court of competent jurisdiction? I peruse Exhibit 05, which is the query given to claimant in this case. Hereunder captured is the relevant portion. Query. Quote, this has reference to the recent discovery of incidents of vandalism and theft of transformers and other electrical installations at the steel making shop, and your subsequent interactions with the Management Committee of Inquiry on the 1st and 22nd September 2015. I'm directed to inform you that you have been indicted for acts of gross negligence of duty and incompetence by the committee as follows: that as the head of the electrical unit of the steel making shop, 1, you failed to organize the unit properly. There was no inspection of electrical equipment whatsoever by your unit. 2, you left the SMS in complete darkness over a long period of time. And 3, your handing over of the keys to the electric rooms, either to under your control, was not documented. You should note that the above acts of gross misconduct are trial summary dismissal in line with the provision of section 8.01.3, 57D of our condition of service. Nonetheless, management has directed that you should be asked to exculpate yourself in writing as to why appropriate disciplinary measures should not be meted on you. Your representation should therefore reach the office of the General Manager, General Administration within 72 hours on the receipt of this letter, unquote. The above content of Exhibit 05 is clear and comprehensible. It is clear that claimant was not alleged of any criminal allegation. He was not alleged of vandalism or theft. Rather, he was only alleged of gross negligence of duty outlined above, which to me is not a criminal offense that's stating that he should be charged before a court of competent jurisdiction. I've equally perused Exhibit K, K8, and K9, which relates to the allegations against claimant, and I can categorically say that there was nowhere in any of those exhibits where claimant was alleged to have committed any criminal offense or any misconduct with criminal elements in it. It is within the right of an employer to investigate and discipline its employee for any misconduct which has no criminal elements without resorting to the court. It is an elementary principle of our labor law that an employer has an unfettered right to discipline its employee, and the court cannot interfere with such right. See the case of MBC, PLC, and ECHO citation captured. Thus, the defendant need not arraign claimant before any court of competent jurisdiction to try him on an allegation of misconduct. I so find and hold.
As God.
It is equally claimant's contention that no disciplinary committee was set up to review and punish appropriately as required by PSR, that the management issued a letter demoting him for the offense. The defendant in this case have strongly maintained that it is the condition of service that binds parties, and claimant's demotion was done in line with the employee's handbook and condition of service. I've held herein supra that the primary conditions of service that governs claimant's employment is that of the condition of service of the defendant, which the defendant tendered as SPK to. Effect of this is that the company's condition of service will be reverted to. It is when the company's condition of service, which is personal to both parties, is silent, that the PSR will be reverted to. As such, this court is bound to first consider the provisions of SBK2 as regards discipline before it considers the provision of PSR, if at all. The defendant has maintained that claimant was given query in line with paragraph 8.04.01 of the employee's handbook and condition of service, that is SBK2. I've gone through the provision of SBK2 with a particular attention on chapter 8, which centers on discipline. In essence, since SBK2, which is the primary condition of service, provides for the procedure for discipline, there is no need to resort to the PSR. Besides, the query above clearly alluded to the provision of chapter 8 on discipline as provided in SBK2. It is therefore clear that it is the condition of service that was applied in the discipline of claimant. I've gone through the provision of chapter 8 with the mastery of an eagle's eye, and I find that paragraph 8.01.3 provides for a series of acts that will amount to misconduct, and listed as number 20 on the list is, quote and unquote, neglect of work or gross or habitual negligence, unquote, which is the misconduct claimed was alleged to have been committed by the claimant. Now, the disciplinary proceedings for misconduct is contained in paragraph 8.04.0, which provides those, and I quote, General, if the nature of alleged misconduct is such warrant dismissal, the following procedure shall be followed. A, the employee shall be notified in writing of the grounds upon which it is intended to dismiss him or her, and he or she shall be given a full opportunity to exculpate himself or herself. B, the matter shall be investigated by the level of management of power to deal with the case. C, if any witness or witnesses are called to give evidence, the employee shall be entitled to be present and to put questions to the witnesses. D, no documentary evidence shall be used against the employee unless he or she has previously been supplied with a copy thereof or given access thereto. E, in lieu of dismissal, management may at its discretion impose some lesser penalties such as reduction in rank, stoppage of increment or reprimand. Alternatively, if the proceedings disclose grounds for so doing, it may without further proceedings require the employee to retire from the company's service. F, if the employee is convicted on a criminal charge, management may, upon consideration of the proceedings of the court, dismiss the employee or subject him or her to some lesser penalty. And G, the above procedure shall also apply to cases of termination of appointment or quote. The above provision of SBK2 is clear and requires no aid to interpret. In the case of Keystone Bank Limited and Clark Citation Capture, the court, Penimpa JCA, held that just like other contracts of employment's creation and termination are subject to the general principle of contract. As such, where the terms of contract are in writing, parties are bound by the express terms of their contract. Duty of the court in such instance is to interpret the terms of contract of the parties and give effect to it. See also the case of Omega Bank Nigeria PLC and OBC Limited, citation provided. The court, in interpreting the terms of the contract between parties, must give the words their plain, ordinary, and natural meaning, where the words used are clear and unambiguous. See the case of SL Petroleum Enterprise Limited and Petroleum Equalization Fund Management Board and another, citation provided. The first requirement is for an employee to be notified of the allegations against him in writing and be allowed to respond to same. From the facts and circumstances and SB tendered by parties in this case, it is clear that an incident of vandalism and theft occurred at the steelmaking shop of defendant, which necessitated that a committee of inquiry be formed to investigate the said vandalism and theft of transformer. A committee of inquiry had indicted claimant and some other staff. Claimant was indicted of gross negligence of duty, and as a result of which he was issued a query to answer to the said allegation of gross negligence of duty. Claimant in this case admitted that he was giving query and he responded to it. Both query and response is on record of this court as Exhibit 05. The next step for the employee to be investigated by the level of management empowered to deal with the case. The defendant have averred that claimant was investigated by a committee of inquiry before who he appeared and defended himself, and a review committee was equally constituted. See paragraph 42, 3 and 4 of the amended joint statement of defense. It is trial law that facts not specifically denied are deemed admitted. See the case of Spain and Dines Supra. It is trial that facts admitted or deemed admitted need no further proof. See section 123 of the Evidence Act, and the case of one overseas agency, Nigeria Limited versus Bromwine Energy Trading Limited, citation captured. The case of RNMA and FC and Johnson, citation captured. The case of Cole and Jibuno, citation provided. Claimant in response by paragraph 33 of his reply to the amended joint statement of defense did not deny that he appeared before these committees. Thus, claimant is deemed to have admitted appearing before these committees, and these facts require no further proof from the defendant. However, it must be noted that claimant only appeared before the committee of inquiry, which first investigated the incidents of vandalism and theft that indicted him for gross negligence of duty, resulted in him being given query on the alleged gross negligence of duty, which he responded to. Thus, a formal allegation against claimant was only made after the committee of inquiry had investigated the matter, which kickstarted the disciplinary process of claimant by the issuance of the query and answer to same. In essence, its disciplinary process of claimant only started with the issuance of the query. The review committee came after the issuance of the query and answer to same. The said review committee, from the facts and circumstances and SB tendered, which sat after the issuance of the query, never had claimant in person. It considered the defense of claimant and other affected officers who were indicted by the committee of inquiry. See paragraph 42, 4 and 5 and Exhibit K9. It was a review committee that came after the issuance of a query that recommended demotion of claimant. From the provision of paragraph 8.4.01 outlined above, the investigation comes after claimant had been given query by the defendant. The review committee, which dealt with the matter after the issuance of the query, merely considered the defenses put up by the affected officers, including the claimant, and then gave recommendation that claimant be demoted, which was acted upon by the defendant, resulting in the demotion of claimant. One would expect that the review committee should have had the affected officers in person before making its recommendation, since the investigation in the real sense of it had happened before the issuance of query for fair hearing. However, it should be noted that the provision of Exhibit K2, that is the condition of service outlined above, did not state how the investigation after the issuance of the query should be carried out, whether physical or otherwise. It merely provided that if witnesses were called, the affected officers should be allowed to put questions to the witnesses, and any documentary evidence used should be availed the affected officers, which obviously are in line with the principle of fair hearing. However, in the instant case, witnesses were not heard by the review committee, which came after the query that kickstarted claimant's disciplinary process. The committee did not even adopt the physical appearance method. It merely considered the defense of the affected officers, which were indicted by the committee of inquiry earlier set up. I've held supra, in this case, that the employment relationship between parties is not statutory, but a master servant where terms and conditions of employment are written down. Courts have held that the requirement of fair hearing in a master-servant relationship is fulfilled by mere issuance of query to an employee, and the employee answers the same. See the case of FBN versus Akonji, Supra, the case of PC, Mykese, and Springbank, Supra, the case of, citation provided, the case of Monike and Unity Bank PLC, citation provided. Thus, it may not be fatal that the review committee, which was set up after the issuance of the query to claimant and whose recommendation was acted upon, only considered the defenses already given by the claimant and other affected officers without hearing the affected officers in person. In the same vein, the outlined procedure equally allows for lesser punishment or penalty in place of dismissal, like reduction in rank, which was what was done in claimant's case.
That's conclusive.
Claimant by paragraph 24(3) of the amended statement of facts have averred, among other things, that it is not his schedule of duty to watch, repair, maintain, inspect, operate the purported electrical equipments. The defendant has controverted it by saying that it is the schedule of duty of claimant as the head of electrical unit of the steel-making shop where the incident occurred to carry out routine checks, which he failed to do, and which made it possible for vandals to carry out this dastardly act. Claimant, by his reply to the amended statement of defense, stressed that though he is the head of the electrical unit, his duties are to work with low voltage, and there is low voltage arm of PT and D unit, of which transformer maintenance is part of their duties. It is of note that the burden of proof in civil cases is not static, but depends on the state of pleadings. This is encapsulated in the maxim, Latin maxim, incumbit provertio qui deceit non qui negat, meaning the burden of proving a fact rests on the party who asserts the affirmative of the issue and not on the party who denies it, for a negative is usually of proof. See these cases, Odom and PDP and other citation captured. Onyeme and another versus Weze and another citation provided. The defendant who is asserting that it is the schedule of claimant's duty to carry out routine checks that he failed to do, thus have the burden of proving same, and not the claimant who is asserting the negative. DW, while under cross-examination on the 16th of October 2016, admitted that claimant does not work with the security unit and that the schedule of claimant's duty is not before the court. Although the defendant failed to present the claimant's schedule of duty before the court, I'm however mindful of the fact that this action is declaratory in nature, and in which case claimant must rely on the strength of his own case and not on the weakness of the defendant's case. See the case Adamu and Nigerian Air Force citation captured. Claimant in his answer to query admitted that he occasionally joined the transformer unit of PT and D to inspect electrical equipment and transformers. Specifically, claimant stated at page 2 on item 1B in his answer to query, which is part of a bundle of documents standardized with 05 doors, and I quote, occasionally, we usually inspect the idle electrical equipment and transformers in conjunctions with the transformer unit of PT and D whenever they come around or the need arises, unquote. Claimant's schedule of duty has not been produced, like I said, before the court by the defendant, who has the burden to prove same for reasons earlier given. He has, however, made tacit admission of the fact that it is within his schedule of duty to carry out routine checks of electrical equipment, including transformers, which means it is not just the duty of a transformer unit of PT and D alone, as is positing in his pleadings. It's equally worthy of note that claimant who is putting up the defense before the court that is not culpable of gross negligence of duty, as alleged by the defendant and ought not to be demoted, is the same person that tendered Exhibit 02, which contains his answer to the query. Claimant in the said answer to query did not at any time raise the issue that it is not part of his schedule of duty to inspect or carry out routine checks of the electrical equipment or transformer. Rather, he responded thus, and I quote, concerning the issue at stake, I declare that I did not fail to organize my unit properly because of the following reasons. A, the entire steel-making shop is an idle plant due to lack of its completion, as earlier said. Hence, our major focus had always been in the following areas: the drainage pump house, the scale pits, exhauster plant, and utilities building pump house, baling press yard, magnetic scrap pit, pump house, cable tunnels, slag processing yard, pump house, cable tunnels, ventilation equipment room, pipe tunnels, pumps, illumination of the shops whenever the materials are available or provided, and emergency services. B, occasionally, we usually inspect the idle electrical equipment and transformers in conjunction with the transformer unit of PT and D whenever they come or the need arises. That the steel-making shop was left in complete darkness for over a long period of time without illumination is not a holistic truth. This is because there is light in the following areas: baling press yard, scrap processing yards, converter shop floor, CCM services bay area, etc., which areas are being maintained by us. However, the areas where there is poor illumination is the surrounding of the steel making shop. Although the idle electrical rooms have no good illumination due to lack of illumination materials or funds procure them. As you may see from the Aptite Progress Report on activities in steel making shop from the month of September 2013 to the month of June 2015, yet every report is still being made on this issue. This is evident in our various divisional meetings. I used to get illumination materials from our store. We were told by the store officers that we are now operating at zero stock level due to lack of materials and funds. Efforts being made by our store officer to get us these illumination items have been in place or put pending with results, unquote. It is clear from the above relevant portion of the claimant answer to the query that at no time did the claimant in defense to the allegation of gross negligence of duty in his query raise the issue of it not being part of his schedule of duty to carry out routine checks of electrical equipment. In fact, the line of claimant defense in the said answer to the query was the idleness of the said steel making shop due to non-completion and poor illumination on the affected part, which is the steel making shop, and which issues is not putting up again. He's not putting up again before the court. It is my respectful view, which is in sync with the submission of learned counsel for the defendant in paragraph 6.02 of the final written address, that the defense of it not being within the schedule of claimant's duty to carry out routine checks as put up by claimant in this case to the allegation of gross negligence of duty is an afterthought. An afterthought has no place in law. In fact, if claimant did not raise it then in his answer to query, that it was not part of his schedule of duty to inspect or carry out routine checks on electrical installations and appliances, including transformers, is a stop from raising it at this stage.
Let's call places.
I'm not unmindful of the submission of learned claimant counsel. In paragraph 4.10 of his final written address, particularly at page 22 of the said address, that the Federal Civil Service Commission ought to play a key role in regulating the affairs and deciding whether the claimant ought to have been demoted, wherein it relies on the case of NEPA and Arubia Kesupra. Let me first state that the fact of that case is clearly distinguishable from the case at hand in that while the defunct NEPA, which was the employer in that case, is clearly a civil servant, and then subject to the control of Federal Civil Service Commission where the need be, especially where PSR governs the employment, the same cannot be said of the first defendant in this case, which is a company incorporated under KAMA with its own condition of service, and the court has reasoned supra. I've held that employees of companies owned by government are not part of the public service, that the definition in section 318 of the Constitution is only for the purpose of code of conduct. Long before now, the Supreme Court have had the opportunity to say one of two things about the involvement of the Federal Civil Service Commission in the affairs of issues of companies owned by government with its own condition of service. In the case of Okomo Oil Palm Limited versus Shenhe, citation captured, the Apex Court per ONU, GSC, had this to say on that, and I quote, besides having a controlling number of shares in a company, is not synonymous with its ownership. Once it is incorporated as an entity of its own and having its own separate legal existence, whatever impression was therefore given in this case, that the Federal Civil Service Commission sat in the background and maintain a direct or remote control over the activities of the appellant by applying thereto its rules. A corporate entity with its own legal existence must be rejected as a wrong and ill-conceived legal proposition, unquote. It is thus clear that the above submission of Learned Claimant Counsel is misconceived, as the first defendant is independent of the Federal Civil Service Commission being a company with its own condition of service. So there was no need for the Federal Civil Service Commission to be involved in the discipline of its staff. I so find and hold.
Ask call, please.
Learned Counsel, just give me a minute, please.
Alesorio. But we never done. The thing is having problem, the network. Opale, you can come and sit outside. Oh, okay. It's judgment too.
Barrister Ayo.
The court is
Yes.
resuming, please. Learned Counsel, the court is resuming, please.
So sorry, my lord.
Very well. Now, as regards claimant's termination, which he is alleging has been unlawful for being in violation of the PSR, claimant by paragraph 24(1) and 3 has averred that the termination of his employment was unlawful and linked same with the alleged offense, which according to him has not been proven against him in the court of competent jurisdiction, that his appointment was terminated without appointment of a disciplinary committee. Without appearing before a disciplinary committee. Just a minute. The defendant has maintained that the termination of claimant's employment had nothing to do with the earlier allegation, which he has been punished for by demotion, that the termination was an exercise of its right under Exhibit K2. Claimant, by the reply to the amended joint statement of defense, maintained that his termination had everything to do with the said allegation for which he has already been punished by demotion. I found supra that the allegation against claimant were not criminal in nature to warrant him being charged before the court. Be that as it may, the pertinent question that should be answered first at this stage is whether or not claimant's termination had anything to do with the alleged offense for which he has already been punished. In order to effectively answer this question, there is need to take a look at the letter of termination, which is herein as Exhibit 07. A perusal of the said exhibit shows that the defendant merely stated that there was an ongoing restructuring or reorganization, and as such, claimant services was terminated for services no longer required. It is clear from the said letter that claimant's termination had nothing to do with the said allegation, although claimant maintaining that from the overt acts of the defendant in this case, the allegation against him leading to his demotion has everything to do with the said termination. It is noteworthy that this is a master-servant employment, in which case the court does not have the power to question the motive of the employer beyond the termination of his servant's employment. Therefore means that the exercise of an employer's right to terminate a contract of employment cannot be vitiated or questioned or on grounds of malice or improper motive. Once no motive is expressed by the employer as the reason for terminating the employment. See the case of Union Bank and Salahuddin citation captured. Thus, even if the overt acts of the defendant shows that it had something to do with the allegation leveled against the claimant, which he had been punished for, the letter of termination, as Exhibit 07, says otherwise, and it is not within the jurisdiction of this court to start prying into the real motive behind the termination. In fact, the courts have held that the requirement that the employer is required to prove the reason for termination is dispensed with when the reason is given is for quote and unquote services no longer required. Although paragraph 8.03.0 of SBK2 provides for termination as a punitive measure, claimant termination in this case as reason supra is not punitive as it has nothing to do with the allegations against you. Besides, the provisions of paragraph 9.01.06 of SBK2 which the defendant pleaded and rely on paragraph 14 of the amended statement of defense, is clear to the effect that the defendant reserves the right to terminate the appointment of the employee. It finds necessary where the service of the where the services of the employee are not required by giving him due notice or payment of salary in lieu of notice. Thus, termination does not necessarily have to be punitive. It can be as a result of exercise of the right of the defendant's company. Accordingly, this court finds that the reason for termination is as stated on the letter of termination as Exhibit 07, and has nothing to do with the allegation that they have made against claimant, and it is within the right of the defendant to do so, even if the claimant has not been alleged to have done anything previously. I bear in mind the submission of learned claimant counsel in its final written address that though the defendant reserves the right to terminate employment for services no longer required, the reason given being reorganization or restructuring must be proven by the defendant, and which the defendant failed to do. As such, the scale has tilted in favor of claimant. The defendant has stated that claimant's employment was terminated for services no longer required due to restructuring. I'm in agreement with learned claimant counsel that the defendant has the burden to prove that there was indeed restructuring. The defendant has to substantiate his claim of restructuring and how that affected the retention of the claimant in its employ. It is its duty to also show that the reorganization or restructuring affected other staff and not only the claimant. The defendant averred that more than 7 staff from various departments were affected. The defendant further averred that the claimant and other affected staff completed their clearance, and the claimant in particular wrote a letter to the admin department seeking for change of the name of his next of kin. It is noteworthy that the claimant's counsel cited some decisions of this court on the need to justify reasons given for termination in paragraph 5.11 of his final written address, which cases are reported. It is the decision of the Apex Court in the case of Ugo Ngadi versus Federal Republic of Nigeria, where Galinje JSC held us, and I quote, where a counsel cites a case that has not been reported, he owes the court a duty to produce a copy of a judgment if he wants this court to rely on such authority. Where copies of the judgment are not produced, the court will have nothing to rely upon. The cases are yet to reach this court. As such, I will refrain from commenting on them, unquote. Learned counsel in citing those authorities, apart from the fact that he failed to provide the copies of those judgments since they were not reported, also did not state the day second decision was delivered by this court. It is as though he never wanted this court to rely on the said decisions. As such, I refrain from commenting or referring to them. It is equally the contention of the claimant that the termination of his appointment was unlawful because no 1 month's notice was given to him. He averred further that he was only paid 1 day's salary in April 2016. Just a minute. In April 2016, and shall rely on payment voucher. See paragraph 24 of the amended statement of facts. The defendant in response contended that though claimant's employment was terminated in March 2016 as Principal Technical Officer 2, and his salary for the said month was paid, while he was paid salary in lieu of notice in April 2016. It averred further that all the affected staff were paid 1 month's salary in lieu of notice, and that when employees' employment is terminated for service no longer needed, without 1 month notice, such officer is only entitled to his 1 month's basic salary, a salary in lieu of notice. See paragraphs 19, 39, and 43 of the amended joint statement of defense. Claimant in response to paragraph 19 of his statement of defense stated B paragraph 14 of the reply to the defense that he worked on the 1st day of April, which was when the termination letter was served on him, and that the sum of 20,788 naira 28 kobo paid by the defendant in April was for the work he did and not payment in lieu of notice, as salary in lieu of notice is made by hand payment and not leave bank bank. The provision of paragraph 9.01.06 of Exhibit K2 alluded above specifically provided that an employee whose service is no longer required is entitled to 1 month notice or 1 month basic salary in lieu of notice. The court in the case of Balu and Federal College of Education, Obudri and another citation captured held that the burden of proving payment of salary in lieu of notice lies on the party asserting the positive, which is the employer in line with sections 131 and 132 of the Evidence Act, and that the employee assertion of the negative does not place any such burden on him. That the employer has the burden to prove that the employee was actually paid. The defendant who is asserting that claimant was paid 1 month salary in lieu of notice and who has the burden to prove same tendered Exhibit K3, which contains 2 pay slips, one for April and the other for March 2016. As agreed by parties, claimant's employment was terminated in March 2016. It is worthy of note that claimant himself tendered the April pay slip as Exhibit 015. From both exhibits, claimant gross earning was 21,759 naira 79 kobo, while his net earning, which was what he was paid, was 20,788 naira 28 kobo. I've also perused the letter of termination Exhibit 07. The claimant was served with the said letter on the 1st of April 2016, which means that he was on duty for the said date. However, the question that begs for an answer is whether the sum of 20,788 naira 28 kobo paid to claimant in April was 1 month basic salary in lieu of notice or his 1 day salary as alleged by claimant. A perusal of a pay slip of March 2016 shows that claimant's 1 month salary is 111,907 kobo, which fact was alluded to by DW under cross-examination. Now, if claimant's 1 month salary as principal technical officer was 111,907.33, how can claimant's 1 day salary be 21,759 naira 79 kobo, or even 20,788 naira 33 kobo, 28 kobo, which was paid as net salary? If my mathematics is not failing me, 111,907 naira 33 kobo divided by 30 days, which is a month, will give us 3,730 naira 25 kobo per day. Which means claimant's 1 day salary is 3,730 naira 24 kobo and can never be 20,788 naira 33 kobo. I find that even though it was not stated in the April pay slip what the sum paid was meant for, it is doubtful that the said sum is claimant's 1 day salary considering the amount. It is in my humble view that the sum of 20,788 naira 28 kobo paid into claimant's account by the defendant is his 1 month basic salary. Having found that the sum of 20,788 naira 28 kobo paid into claimant's account is his 1 month basic salary in lieu of notice, that, in my respectful view, is in fulfillment of a contract of employment. It is the law of common that when an employee is paid a salary in lieu of notice in compliance with the contract, and the employee did not return it, it renders the termination mutual. In other words, the claimant is deemed to have accepted his termination. See the case of Ekeagu and Nigeria Army citation captured. The case of Borofala and Parastech citation also provided. It is in the light of this tried position of the law that I find that the termination of claimant's employment by the defendant is mutual. I so find and hope. Assuming but I'm not conceding to the fact that the said sum paid in the April pay slip of the claimant was even claimant's 1 day salary, which would mean that claimant has not been paid 1 month's basic salary in lieu of notice. Is that enough to declare the termination of claimant's employment unlawful? The answer is in the negative, and I will explain why. There's no doubt that failure to pay 1 month's salary in lieu of notice is a breach of the term of contract as contained as K2. However, the courts are of the opinion that where the employment is not, one, protected by statutes as in this instance, breach of the term of employment is not enough to declare the termination unlawful or null and void. See the case of Obama and SPDC citation provided. ASC, CPN, now retired, held, and I quote, except in employment governed by statute, wherein the procedure for employment and discipline, including dismissal of an employee, are clearly spelled out. Any other employment outside the statute is governed by the terms under which the parties agree to master a servant. In other cases, governed only by agreement of the parties and not by statute, removal by way of termination of appointment or dismissal will be in the form agreed to. Any other form connotes only wrongful termination or dismissal, but not to declare such dismissal null and void, unquote. See also the case of Patrick and C citation captured. Accordingly, I'm unable to find the termination of claimant's employment unlawful, illegal, null, or void, as claimant will want me to so declare. Of all reasons supra in this judgment, I'm unable to find either claimant's demotion or termination as unlawful or in breach of the condition of service I so find and hold. I will now take reliefs 1, 3, 4, 6, and 7 together for the obvious reasons that they are related and interwoven and all concern the termination of claimant's appointment and right to be paid salaries. Claimant by relief 1 seeks a relief claiming the sum of 114,386 naira 50 kobo as salary per month with effect from April 2015 until this action is determined, while he's seeking a declaration that his employment was unlawfully terminated and entitled to be paid 114,386 naira 50 kobo as salary per month with effect from April 2016 in relief 3. In the same vein, claimant in relief 4 is asking for a declaration that termination of his employment is unlawful, illegal, void, and of effect having been carried out in flagrant disregard of the PSR and the defendant's condition of service, while he seeks an order of this court that his appointment was unlawfully terminated and is entitled to his salaries at the sum of 114,386 naira 50 kobo with effect from 1st April 2016, and other allowances and benefits on the determination of this case. Is equally by relief 7, asking for a declaration that is entitled to be paid all his salaries and allowances until the PSR is resorted to. I'm hearing before held that it is the condition of service of a defendant which is the primary document that will be considered in determining the rights and liabilities of parties and not the PSR, except where the condition of service is silent. As reasoned earlier in this judgment, the condition of service has made copious provisions for termination of service. For service no longer required, which is the case in this instance. I've also held, for the obvious reasons given earlier, that termination of claimant's employment cannot be found to be unlawful, illegal, or null and void, and for the obvious reasons given earlier. It is thus clear that the termination of claimant's employment cannot be declared as unlawful, illegal, null and void as claimant seeks in relief 3 and 4. If claimant's employment cannot be declared unlawful, then it means that claimant cannot be asked to be paid beyond the termination date. This is because the trial principle of our labor jurisprudence is that even where, excuse me, even where termination was done in breach of the terms of employment, the court cannot foist a willing employee on an unwilling employer. See the case of HABU-MB versus Kanyip, citation captured. In the same vein, the law is on ephemeral terror that an employee cannot claim for salaries for work not done. See the case of Limited versus Nwanko. The notorious case of Olatu was nicer. Thus, the court does not have the jurisdiction to declare that claimant is entitled to be paid for the period beyond termination or other payment of claimant salaries beyond the period of termination as claimant will want this court to declare. Be of all the above, I find that release 1, 3, 4, 6, and 7 fail. I will take release 2 and 5 together for the obvious reasons that both declarations and order on the right of claimant to pension, that both found the declaration and order on the right of claimant to pension. It is the contention of the claimant that is entitled to pension and gratuity and other benefits allowed under the PS. The defendant on its part, by its pleadings, admitted that claimant is entitled to payment of pension and gratuity. It is tried that facts admitted need no further proof. However, the contention of the defendant is that claimant was supposed to complete his documentation for enrollment for payment of pension and gratuities, but failed to complete the documentation. See paragraph 44 of the amended joint statement of defense. Claimant in response, paragraph 34 of the reply states that he was not due for retirement. His appointment was wrongly terminated and a letter was issued to him for verification, which he refused because he was wrongly demoted before his appointment was also terminated, and the reason is in court. The above in itself is an admission on claimant's part that it was one that refused to document for enrollment to be paid pension. I find that claimant is entitled to pension and gratuity as admitted by the defendant and should be paid his pension and gratuities after he has finished necessary documentation. Thus, reliefs 2 and 5 succeed. I'll take reliefs 8 and 11 together. Claimant in this case seeking that the demotion and termination be declared and ordered as double jeopardy, being punishment for the same offense. It is the law that a person shall not be punished twice for the same offense. However, in this instance, I've earlier held that the termination of claimant's employment is not punitive and equally has nothing to do with the allegations against him. Claimant has clearly been demoted for negligence of duty, and his appointment was subsequently terminated for a different reason. Thus, it cannot be said that claimant was punished twice for the same act for reasons earlier given. It is in the light of this that I find that reliefs 8 and 11 equally fail. Claimant by relief 10 is urging the court to declare that the sealing up of his official residence for 8 days without order of court is illegal, unlawful, null and void. Claimant beat his pleadings of earth that his service apartment was locked up for 8 days before the intervention of Public Complaints Commission. The defendant on his own part vehemently contended claimant's assertion and maintained claimant himself voluntarily left and even surrendered his key to the manager and even indicated same on the clearance form. Claimant in support of his assertion tendered pictures of a locked up apartment as exhibit 014. Let me say that on the day claimant's exhibit were tendered, the defendant was absent. When the matter came up for pre-examination, he equally did not raise the issue of the admissibility of any of the exhibits already tendered by the claimant. Thus, it means the pictures were admitted without any objection. It is, however, worthy of note that the court is under a duty to admit and act only on an evidence which is admissible in law, whether the opposing party objects to it or not. See the following cases: Benjamin and Calio, citation capture, Shitu and Fashawe, citation also provided. Supreme Court in the case of Musa and the state citation provided held. The photographs are in the nature of secondary evidence and to be admissible, the negatives must be tendered along with it. The court went further to state that, however, in this age of digital photography, where negatives are stored electronically, it becomes necessary for the photographer to be called to testify as to the process of snapping the photograph. See the case of Alaji, Ishiaku, Yakubu Enterprise Limited, and Teru, citation capture, the case of Ekwan and another, and Cross Lines Limited and another citation provided. In the instant case, there is no evidence that the pictures are digital, and the court cannot speculate. Even if the picture is digital, the photographer was not called to testify or at least file a certificate of compliance as required under Section 84 of the Evidence Act, since the digital camera can be rightly classified as a computer. It was not stated either that claimant through whom it was tendered was the photographer, in which case it could be tendered through him after he has testified as to the process of snapping the picture and printing of same. The negative of said photographs were equally not tendered with it. The decision of the Supreme Court in the case of Alaji Ishiaku Supra is a decision which I'm bound by. I therefore expound the photographs from the record of this court for not meeting the necessary requirement for its admissibility. Of employment with the defendant. Thus, is a service tenant. The courts have held that an employee who occupies an apartment by virtue of his employment occupies no estate therein and is merely a licensee who has no right to continue to remain in occupation of the premises after the termination of the employment. See the case of Wana and FCDA, Sheka and Bashari, Chukum and Shell Petroleum Development Nigeria Limited citation provided. It must be noted that a licensee is not a statutory tenant who can be protected by law. See the case of Kiamu and Follow Shop, citation provided, and the case of Kari and Ganaram. As such, a licensee can be evicted at any time without the issuance of the statutory notices. However, it is clear from the case law authorities that when a licensee is to be evicted at any time, the licensor wishes, such a licensor must give notice to the licensee. The Court of Appeal per JCA, in the case of Shekan Bashari Supra, held us, and I quote, the law is that if a license is given gratuitously, it is revocable by notice given at any time, and in such situation, the licensee must leave the premises, otherwise it will become a trespasser, as his continued occupation will be wrongful, unquote. See also the decision of the Supreme Court in the case of Chukwuma Petroleum Development Company Supra. It is thus clear that before the licensee is evicted, he should be given notice at any time, which notice does not need to comply with the length of statutory notices, and when he refuses to leave, he is treated as a trespasser. The point must also be made that force or self-help should not be resorted to in the bid to reject such a trespasser. See the case of Sheka and Bashari Supra. The court will not protect a person who, even with a valid right, resorted to self-help without a court order. See the case of Ukochi and Anim Koi, citation provided. In an instant case, if it is proven that the defendant actually locked up claimant's apartment even though he has become a trespasser, such an act would be an act of self-help, which this court will not condone. Claimant in this case is relying on the picture standard and which this court has expunged for reasons earlier given. In the absence of those pictures, there's nothing before the court to show that claimant's apartment was locked for 8 days as alleged. Although claimant maintained that his apartment was locked for 8 days until the Public Complaints Commission intervened and it was opened, support of which he relied on the letters written to and by the Public Complaints Commission, which were admitted as part of a bundle of documents marked as Exhibit 011. I perused the said exhibit and I do not find anything therein to show or even allude to the fact that claimant's apartment was locked for 8 days as alleged. The letter stamped received on exhibit on the 1st of November 2016 on the letterhead of the Public Complaints Commission to the administrator of the first defendant, merely appealed to the defendant to suspend action on the quiet notice or on the quit notice given to the claimant whose complaint is before the commission, whose apartment is at flat 13A, Road E2, Kaduna Estate, Ajaokuta. There's nothing in the said letter that alludes to the fact that claimant's apartment was locked up. The court cannot impute what is not contained in the letter into it. The defendant contended that claimant's apartment was not locked up because he filled the clearance form, which indicated that he submitted the key of his apartment himself and tendered his support as with K4. Claimant, in reply to the statement of defense, maintained that he filled the form because he was told to do so. GW has stated under cross-examination that upon termination of claimant's employment, he was told to commence clearance. Now, I've gone through the said as with K4 vis-a-vis the facted issue, and it is not in contention that claimant did fill the said form, stating that he has submitted the key of the apartment. The presumption is that he understood the content of a said letter before signing and is not raising a plea of non-expertum or coercion. Hence, I find the excuses he was raising to be untenable. Claimant signed that he has submitted the key. The key has been collected. Thus, I do not believe that the apartment was locked up. It is tried principle of law that oral evidence cannot discredit clear contents of a document. Claimant, if he does it, that his apartment was locked up for 8 days cannot contradict or discredit clear contents of Exhibit K4, which shows that he submitted the key. In view of the foregoing, I'm unable to find that claimant's apartment was locked up for 8 days, thus relief 8 fails. Claimant by relief 16 is claiming for general damages. It is the law that general damages are awardable where wrong is established. Thus, where there is no wrong or proof of wrong, there can be no award of general damages or compensation. Excuse me. See the case of George Akande versus Enterprise Bank PLC, citation captured. Let me also say that general damages can be granted in cases where a breach of contract is established. Must also be stated that it needs not be specifically pleaded or proved contrary to what learned counsel for the defendant will want this court to believe. In paragraph 6.01 of the reply address, can be awarded once there is an established wrong or breach, even where it was not specifically pleaded. See the case of Elf Petroleum versus Zuma and other citation captured, the case of Ajabule and another versus UBM, citation captured. Sorry, the case of UBM PLC versus Ajabule and another citation captured. However, claimant in this case has not been able to establish satisfactorily any wrong or breach of the condition of his employment. I therefore do not think he's entitled to general damages. Therefore, relief 16 is refused and thus fails. Claimant in the last relief 17 is claiming for cause of action, though not assessed. He passed the burden of assessment on to the court. Judicial authorities, especially by the Apex Court, have restated the position that a successful party is entitled to costs which it should not be denied, except for good reasons. See the case of Kappa and Alberto Nigeria PLC versus NDIC, citation captured. It is usually at the discretion of the court once empowered by the rules of court to award costs to a successful party. However, claimant in this case has not succeeded in the most part of his claim. I therefore do not find any reason to exercise my discretion to award costs in his favor. Therefore, relief 7 fails. For the avoidance of doubt and for reasons earlier given, I find that claimant's case only succeed in part and thus declare an order as follows. 1, that the demotion of claimant and termination of his employment is not unlawful, null and void. 2, that claimant's employment is pensionable and is entitled to be paid his pension and gratuity, and it should be paid after he has done the necessary documentation for enrollment. 3, reliefs 9, 12, 13, and 14 are struck out. And 4, reliefs 1, 3, 4, 6, 7, 8, 10, 11, 16, and 17 fail. No orders to cost. Judgment is accordingly entered. Parties are entitled to clean copies which will be sent to Lokoja. Very well. I'm rising from Lekoja.
As copies.